Hi everyone. Today's session is commercial trust law. My name is Shazia Khan, and today we'll be doing the learning outcome 4, which is to understand the relationship between the law of trust in an international setting. So looking at different jurisdictions and the laws in regards to trust. Before I go on to learning outcome 4, I want to go just give you a summary of what we did in the last session, which was learning outcome 3. In the last session, we looked at learning outcome 3, which is to understand the differences between the rights, duties, and powers of trustees operating commercial trust as opposed to those operating family trust. So we looked at the difference between each one. For this session, we looked at the powers, duties, and rights of trustees in a family setting. We also looked at the powers, duties, and rights of trustees in a commercial setting, comparative trusts, nature of a trust, so the comparison between commercial and family settings. We looked at trustees' duties and powers, things like, fiduciary duties, duty of care, duty to comply with the terms, duty to act in the best interest of the beneficiaries, the power to manage and invest trust assets, the power to appoint and remove beneficiaries, and the power to amend the trust deed. We then went to look at the differences between commercial and family trusts. And we went on to 3.1, which was to evaluate the powers of a trustee operating a commercial trust and one operating a family trust. Firstly, we looked at, excuse me, the powers of a trustee operating a commercial trust. We looked at investment powers. So how trustees of commercial trusts often have broad investment powers to manage trust assets effectively, and these powers may include things like the authority to buy, sell and trade securities, real estate and other investment instruments. We then went on to look at, in regards to commercial trust, business management, so what it involves, such as business interests or corporate assets, and what the trustees may have the power to manage and operate the business. In regards to commercial trusts, we looked at contractual powers, so where trustees of commercial trusts may have the authority to enter into contracts and agreements on behalf of the trust, like things like negotiating terms, executing contracts, and enforcing contractual rights and obligations. And we went on to then look at, in regards to commercial trust, the discretionary distributions. So commercial trustees may have a discretionary to distribute income or assets to beneficiaries based on the terms of the contract. We looked for commercial trusts, we looked at the risk management. So trustees of commercial trusts have a duty to manage risk effectively, to protect assets and to minimize any sort of liabilities. And this can involve things like implementing risk management strategies, obtaining insurance coverage, and seeking professional advice on things like legal issues, financial issues, and any regulatory issues that may matter. We then went on to look at the powers of trustee operating a family trust. We again looked at the asset management of that, so what they're responsible for. So managing trusts for the benefit of the family members and other beneficiaries. And this could be things like investing trust funds, maintaining real estate properties, and managing financial assets such as stocks and bonds. We then looked at the estate planning, where family trustees have the power related to estate planning, such as the authority to make distributions to beneficiaries, establish trusts for minor or incapacitated beneficiaries, or any sort of tax planning strategies, and also how trustees must consider the long-term financial needs and welfare of the family members when exercising these powers, taking into account such as things like, the education, the healthcare, and the quality of life. If anyone has any sort of disabilities or anything like that, all these trust and the factors need to be taken into account when putting a trust together. We looked in regards to family trust at dispute resolution. where trustees of family trusts have the power to resolve disputes among family members or beneficiaries regarding trust matters. We then went on to look at family support. So family trustees may have discretion to provide financial support or assistance to family members in times of need. So this may include things like, education costs, healthcare costs, any sort of financial needs. And then education and advancement. So trustees of family trusts may have powers related to education and advancement for the beneficiaries. This could be things like educational expenses, providing for skills development or vocational training, or supporting any sort of entrepreneurial endeavours. And they must balance the needs of current and future beneficiaries to promote any sort of personal and professional growth. We then went on to look at 3.2, which was looking at comparing and contrasting the rights and duties imposed upon a trustee of a commercial trust or family trust. So we looked at the rights for commercial trusts. So we looked at their rights such as investment powers, where trustees of commercial trusts often have broad investment powers to manage trust assets prudently and maximize returns. We looked at management authority, where commercial trusts trustees typically have extensive management power over trust assets, or including the power to sell, buy, lease, or deal with trust property in the ordinary course of the business. We then went on to look at the contractual powers, such as trustees of commercial trusts have the power to enter into contracts and agreements on behalf of the trust, such as lease agreements, any sort of financial agreements, business contracts. We then went on to look at fiduciary duties, how trustees of commercial trusts owe fiduciary duties to the beneficiary, and prudent management, so where trustees have a duty to manage trust assets prudently in accordance with the standard of care expected of a prudent investor. We then went on to look at compliance obligations, where trustees of commercial trusts are responsible for ensuring any compliance with legal and regulatory requirements governing trust administration, including tax laws, financial reporting standards, and industrial regulations. We then went on to look at the rights and duties within family trust trustees. So their rights was distribution discretion. So trustees of family trusts often have discretionary powers to distribute trust income or assets to beneficiaries based on the terms of the trust deed and the trustees' discretion. We went on to look at asset management for one of their rights, which is family trustees may have authority over trust assets, including the power to invest, manage and administer trust property for the benefit of the beneficiaries. We then went on to look at decision-making as one of the rights as well, where trustees of family trusts may have decision-making authority over significant trust matters such as investment strategies, distribution policies, or succession planning. And their duties for family trustees, so they've got a fiduciary duty similar to commercial trustees. So it's very similar how in regards to what the duties are for commercial trusts, family trustees, or fiduciary duties to the beneficiaries, and they including things like, the duties of loyalty, to be loyal to the beneficiary, not breach any of their fiduciary duties, and provide care and be impartial as well. They must act in the best interest of the beneficiaries and avoid any sort of conflict of interest or self-dealing that could undermine any sort of trust integrity. And the next duty is beneficiary consideration. So trustees have a duty to consider the needs and interests of the beneficiaries when exercising their powers and making decisions regarding trust administration. And again, they must act impartially and without favoritism, ensuring that a fair treatment and equitable distribution of the trust benefits among beneficiaries. The next duty for family trustees is confidentiality and privacy. And trustees of family trusts have a duty to maintain any sort of confidentiality and privacy regarding any sort of affairs, including things like trust assets, any sort of distribution issues, and any sort of beneficiary information. They must respect the privacy rights of beneficiaries and refrain from disclosing any sort of sensitive trust-related information about any sort of authorization. So when we looked at both in regards to trustees of commercial trusts and family trusts, they're very similar in their fiduciary powers to act in the best interests of the beneficiary. Their rights and duties differ because of the nature and objective of the trust. Commercial trusts often have broader powers relating to things like, investment, more to the property side of it, commercial, while as family trust tend to mainly focus on distributing the assets, fairly to the family and being impartial again. And but both types of trust must adhere to rules, legal rules and ethical standards to fulfill their obligations, but also safeguard the trusts as well. So that was learning outcome 3. And now we're going to go on to learning outcome 4, which looks at understanding the relationship between the law of trust in an international setting. So the indicative content is to look at US law relating to trust creditors, trust assets, creditors' rights, and corporate trustees. So it's very important to look at the different laws in the different jurisdiction, because it gives you an idea of the laws in UK and different jurisdictions in regards to trusts. Okay, so key terminology: trust creditors, creditors' claims against trust assets, creditors' rights and remedies, fraudulent transfers and creditor protection, then trusts assets, trust definition and classification of trust assets, asset protection and segregation, and commingling of trust assets. Number 3, we looked at creditors' rights, which is creditors' access to trust information, creditors' standing to enforce trust terms, also looking at creditor priority and distribution of trusts, and looking at creditor corporate trustees, and looking at duties and responsibility of corporate trustees, regulation and oversight of corporate trustees, liability and indemnification of corporate trustees. So we looked at number 5, key principles, fiduciary duties of trustees, duty of loyalty and impartiality, which we're looking at, duty to preserve and protect assets, and the duty to account and provide information. Relevant legislation and case law, so the Uniform Trust Code, relevant state trusts, and significant court decisions on commercial trust issues. So 4.1, analyse commercial expectations of trust creditors. So when we look at trust creditors, we identify the importance of what they are and what they're concerned. So a trust creditor really has the right to look to the trustee's right of indemnity associated lieu over trust assets, and is entitled to subrogate those rights. So it's really important if you want to protect assets with the trust. Some irrevocable trusts will do the trick. When you put money in the irrevocable trust, once you have control, you can irrevoke it. So it's really important to look at other jurisdictions and how they apply their laws as well in regards to commercial expectations. So 4.1, look at analysing commercial expectations of a trust creditor. So analysing the commercial expectations of a trust creditor involves understanding the perspective and requirements of creditors who extend credit or provide goods or services to trust. Here are several considerations. So firstly, the repayment assurance. Trust creditors typically expect assurances regarding the repayment of debts or fulfillment of obligation. They may assess the credit worthiness of the trust, including its assets, income streams, and financial stability. to determine the likelihood of repayment. Creditors may require guarantees, collateral, or any other security interest to mitigate repayment loss. So any creditors that are in this situation would have the expectation that, they will be paid. That the trustee will give them, the general function is that the trustee will distribute anything to them in regards to any sort of, if there's any sort of, bankruptcy or anything like that, that the trustees would be able to pay the creditors and agree a creditor's liability, because the trustees will be liable to pay the creditors depending on what kind of creditors they are. The next one is transparency and disclosure. So trust creditors expect transparency and disclosure regarding the trust's financial status, assets, liabilities, and cash flow. They may request financial statements, asset inventories, trust deeds, and other relevant documents to assess the trust's creditworthiness and make informed lending decisions. The next one is enforceable rights. So trust creditors expect enforceable rights to recover debts or seek remedies in the event of default. They may seek contractual provisions, security interests, or legal remedies that provide assurances of debt recovery, such as liens, as we mentioned, pledges, or rights to pursue against trust assets or beneficiaries. So, they need that assurance, because if, as a creditor, you have to, be able to get your expenses back. Once a company becomes insolvent, they have to, creditors have rights that they would have to be paid. So priority and ranking. So trust creditors consider their priority and ranking in the event of insolvency or liquidation. They may assess the hierarchy of creditor claims and the likelihood of recovery debts ahead of other creditors, such as secured creditors, which we mentioned earlier, unsecured creditors, or beneficiaries with equitable interests in trust assets. Risk assessment. So trust creditors evaluate the risks associated with lending to trusts, including credit risk, market risk, liquidity risk, and legal risk. So the creditors would need to evaluate any sort of risks before they, start lending to the trust and things like that. So all this needs to be done well before. They may conduct due diligence, assess market conditions, and analyse the trust financial performance and governance structures to mitigate any sort of potential risks and ensure prudent lending practices. Also, contractual terms. Trust creditors negotiate contractual terms and conditions that govern the lending relationship, including interest rates, repayment schedules, covenants, default provisions, and dispute resolution mechanisms. They seek terms that provide adequate protection and remedies in case of default or breach of the contract by the trust. So, these all need to be taken into account, if a company goes into administration, it must pay every creditor entirely, and, it's even, try to prioritize these. So creditors need to be, be able to look at this in regards to what rights they have when a company becomes insolvent, or if there's any sort of liquidation, going through, or bankruptcy, what duties the administrator has to the creditor. Regulatory compliance. So trust creditors expect trust to comply with the applicable regulatory requirements, such as financial reporting standards, disclosure applications, obligations, licensing requirements, and consumer protection law. Non-compliance with regulatory requirements may increase the risk of legal disputes, regulatory sanctions, or reputational damage for both the trust and its creditors. Communication and relationship management. So trust creditors value open communication and effective relationship management with trustees and trust administrators. They may seek regular updates, financial information and performance reports to monitor the trust's financial health and address any concerns or issues proactively. So the main duty of the administrator is really to realise that the company's assets for the benefit of the creditor. Their role is very similar to that of a liquidator. So, they need to bear in mind what the creditors, do they have rights? If something is breached, if there's a breach or anything, do they have any rights? Are they able to get any sort of finances back? It all needs to be taken into account when looking at different creditors, and if they are repaid, it will depend on what type of creditors they are. Like we mentioned, you'd have secured creditors, you'd have who have secured creditors with a fixed charge, typically include the bank and other lenders. Then you'd have office holders fees, you'd have preferred creditors, and these include things like, employees of the company. And then you have creditors with the floating charge, which we mentioned in the last learning outcomes, and the prescribed ones. So floating charge, it actually covers a class of asset rather than a specific item. So it could be stock. And then we've got unsecured creditors, and these claims made by unsecured creditors lie at the bottom of the hierarchy for payment. So which means by this stage, their return is typically low. So payment is made through like unsecured assets. And then you've got connected unsecured creditors who are associated with the company in some way, family members, for example, and they rank the right to the below. So you've got risk mitigation strategies. So trust creditors implement risk mitigation strategies to safeguard their interests and minimize potential losses. They may diversify their lending portfolios, monitor credit exposures, purchase credit insurance, or engage in hedging activities to manage credit and market risks associated with lending to trusts. Then we've got legal protections. Trust creditors rely on legal protections such as contract law, property law, insolvency law, and trust law to enforce their rights and recover debts in case of default. They may seek legal advice, pursue any sort of legal remedies, or initiate legal proceedings to protect their interests and maximize debt recovery from trusts. So in conclusion, in summary, analysing the commercial expectations of a trust creditor involving assessing repayment assurances, transparency and disclosure requirements, enforceable rights, priority and ranking considerations, risk assessment, contractual terms, regulatory compliance, communication and relationship management, risk mitigation strategies, and legal protections. By understanding and addressing these expectations, trust can maintain a positive relationship with creditors and access, the financing support. So, it's really important that, if a company is to go into any sort of liquidation, they have based, their relationship with creditors so that they can support the creditors throughout this, because creditors' rights, they do have rights under insolvency laws, and there's laws in place that will protect creditors in regards to what they are, what creditors' rights are in any sort of administration of an organization. So, it is, so if a company is placed under any sort of administration, an automatic moratorium is enforced that prevents creditors from pursuing any sort of legal proceedings against the companies and its assets. So it's important to emphasize that company administrators are appointed in order to benefit creditors. Creditors take priority, and as we mentioned, the different types of creditors. It's common for secure creditors to hold a debenture conferring fixed or floating charges over the assets of the country, over the company. So it's really important to bear in mind that the different types of creditors have different rights. Individual creditors' rights in administration will depend on the type of creditor, as we mentioned. So there may be a secured creditor, preferential creditor, unsecured, depending on the type of creditor they are, will depend on what they get. Now we're going to look at 4.2, which is to compare the law relating to trust creditors in other jurisdictions. So comparing the law relating to trust creditors across different jurisdictions involves analysing various legal principles, regulations and practices governing the rights and remedies of creditors who extend practices governing the rights and remedies of creditors who extend credit or provide goods to or services to trusts. Here's a comparison of trust credit laws in several jurisdictions. So first we'll start with the United States. In the US, trust creditor laws varies dependent by state, as trust law is primarily governed by state statutes and common law principles. And because there's different trust laws in different countries, you know, the obligation is that, you know, dependent on what country you're in, trust laws will differ. They have different governing powers. So creditors may seek to enforce their rights against trust assets through mechanisms such as fraudulent transfer laws, creditor claims against trust distributions, or actions to pierce the trust veil in cases of abuse or fraud. The Uniform Trust Code, UTC, provides a model framework for trust laws across states in America, including provisions and addressing creditor rights and remedies. So there will be lots of similarities in a lot of the rights and remedies for creditors, or in regards to, you know, any sort of duties and rights they have, but they would be in accordance with the law that's governed by each state. The United Kingdom. So trust creditor laws in the UK are primarily governed by the Trustee Act 1925 and subsequent legislation as well to common law practices. Creditors may seek to enforce their rights against trust assets through mechanisms such as equitable execution, charging orders, or actions for breach of trust or negligence against trustee. The Insolvency Act 1986 provides specific provisions regarding creditor rights in cases of trust, insolvency, or any sort of bankruptcy. In Canada, the next jurisdiction that we'll be looking at is Canadian one. In Canada, trust creditor laws vary by province, as trust law is governed by provincial statutes and common law principles. Creditors may seek to enforce their rights against trust assets through mechanisms such as execution against trust property tracing claims, or actions for breach of trust or fiduciary duty against trustees. So there are links between different countries and different jurisdictions. The Bankruptcy and Insolvency Act provides specific provisions regarding creditor rights in cases of trust insolvency or bankruptcy. Australia. So trust creditors laws in Australia are primarily governed by the state and territory legislation, as well as common law principles derived from English trust law. So, you know, it bases its laws around English trust law and the principles derived within common law. So historically, creditors may seek to enforce their rights against trust assets through mechanisms such as equitable execution, charging orders, or actions for breach of trust or negligence against trustees. The Corporations Act 2001 provides specific provisions regarding creditor rights in cases of trust, insolvency, or corporate trustee bankruptcy. Offshore financial centres. So what are offshore financial centres? It's defined as a country or jurisdiction that provides financial services to non-residents on a scale that is inconsistent with the size and financing of its domestic economy. Offshore jurisdictions offer favourable trust creditors laws to attract business, including robust asset protection, statutes, limited liability provisions for trustees, and creditor-friendly dispute resolution mechanisms. Offshore jurisdictions may have specific trust legislation, such as the Cayman Islands Trust Laws or the British Virgin Islands Trustee Ordinance, which govern the rights and remedies of trustees. It provides corporate and financial services, as we mentioned, to non-resident companies on a scale that is huge. Traditionally, offshore financial centre are assumed to be small, low-scale, low-tax jurisdictions in remote locations. Offshore financial centres are categorically distinct from other kinds of financial centres, such as international financial centres, which are referred to IFCs, while IFCs are categorised by strong regulatory structures, substantial participation in the domestic economy and diverse funding sources. Offshore financial centres are distinguished by weak regulatory and supervisory checks. Financial services that appeal to corporations and individuals looking to avoid taxation and large amounts of banking secrecy and shadow banking. Though offshore financial centres serve a handful of legitimate business purposes, they also serve slow, dubious, and often overtly criminal purposes, because financial operations in these jurisdictions are not subject to robust beneficial ownership requirements. Tax evasion and money laundering processes are rampant in the offshore financial centres. So, it contains, they contain a financial structure, but they also allow a form of money laundering as well. So you have to be careful with these offshore financial centres. Civil law jurisdictions. In civil law jurisdictions such as France, Germany, or Japan, trust creditor laws may differ significantly from common law jurisdictions due to the distinct legal traditions and principles. Civil law jurisdictions may have statutory provisions or judicial precedents governing creditor rights in relation to trusts, with emphasis on principles of fairness, equity, and creditor protection. In conclusion, in summary, comparing the law relating to trust creditors across jurisdictions involves assessing differences in statutory frameworks, common law principles, judicial interpretations, and regulatory practices governing creditor rights and remedies in relation to trust. So, bearing in mind that every jurisdiction has, different laws for its states, different regulatory principles, different judicial interpretations, frameworks, policies in place, regulations. So you have to take these into mind. Understanding these variations is crucial for creditors, trustees, and trust beneficiaries operating in international contexts or dealing with cross-border trust structures. So a lot of the laws and everything need to be taken into account when you are looking at trustees and beneficiaries and how they operate, looking at their rights and duties. You must take in the laws of them countries into account to identify if, it's appropriate, any sort of jurisdictions, any laws, their duties. So now we've finished learning outcome 4. These are some of the references we've used for learning outcome 4. Which is bridging the gap, the need for international framework for recognition of trusts, Burroughs, the conflict of laws, Chamberlain, international trusts, globe law and business, Davidson, the international trust rootledge, D. Cruz, comparative succession law, volume 2, intestate succession, Ellickson, property in land, which is a journal article, Hague Conference on Private Law on the law applicable to trusts, on their recognition, which is the links there for you to go on. Also HATEN, which is commentary and cases on law of trust and equitable remedies. CARES, the restatement of trust, what it means for the future of trust in the United States. Mitchell, commentary and cases on the law of trust and equitable remedies. Smith, international trust and divorce litigation. And St. John, trusts and trustees in an international context. Underhill, law relating to trusts and trustees. And Virgo, the principles of equity and trust. So we finished learning outcome 4 now. The next session is the assignment discussion session on the subject area, commercial law trust. And also, please, can you refer to Moodle for any ebooks, any journals, additional reading that you can go on to in regards to this unit. If you have any questions or any, if you want to ask anything about any resources, please email learnerwork@ukvarsity.co.uk. Submission of assignment is to be done on learnerwork@ukvarsity.co.uk, and submission is 2 weeks after the completion of the unit. So the next session we've got is to do with the assignment discussion session. Thank you for attending today's session, and I will see you in the next session. Thank you.